where I take them where they sit, because if they go poo-poo or pee-pee, they're gonna make a mess. And I ended up foolishly getting the third dog, 10 and a half weeks old, chocolate lab, cost me $900 last Sunday. Not this Sunday, the Sunday before. So it's going on 8 days. But I want the court to work with me. I want you to consider my rights, because the neighbors have been pushing me around. It's been going on 5 years. It has had a dramatic effect on me. And I just wonder, their hands are not clean, Your Honor. So these charges that have to do with the neighbors, the dual buildings, they are subject to mitigation. I want to explain this. I'm going to file a civil lawsuit.
I'm unmuted.
Okay, and you're also undressed, so you need to make sure you have a shirt on. You're in.
All right.
Get out,
I'm sorry.
Get out, and you should not be in bed either. And why are you on Zoom anyway?
Because they gave me the paper, told me to come on here.
Sir, you are to be in person today.
They told me my paper don't say no person, it says on Zoom.
If you are still in custody, it's on Zoom.
Oh, well, I asked the dude, he said it was on Zoom. I asked him when I walked out.
Who's the dude?
The guy who gave me my paper.
Okay. Can you hand me Mr. Gardner's file, please? All right, you're just sit tight for a minute. Just make sure you have a shirt on. All right, okay. Good morning, Deputy Provanci. Oh, you're muted. Sorry, you're muted.
Good morning, Your Honor. How are you and your staff?
We're off to a rip-roaring start today.
Okay, I have a total, very well, thank you. I got a total of 4 defendants for you today. Currently, I have Joseph DePrima, and then I have 3 en route to me as we speak. I'm going to have a Autumn Bullshack.
Okay.
Then I got a Craig Culver. And then we're going to have a Amy Stern. Now, Stern and Bullshack are en route to me. They should be here in less than 2 minutes. I'll put the girls on first.
Okay, thank you. Stern? Oh, that's one. Okay. All right, and then I see we have Wayne County Jail Division 2. Your name, please?
Brandon David, Your Honor.
Brandon Haven?
David with a D, I'm sorry.
Oh, David.
Yes, ma'am.
Oh, there we go.
Good morning, Your Honor.
All right, good morning. Okay. So this is Mr. Gardner. Okay, Mr. Gardner, you have your paperwork in front of you? Please unmute.
No, I do not. I got it in my mom's car right now.
Okay. Well, perhaps you should have looked at it, because it says Zoom and gives the Zoom ID in parentheses, says if in custody. Are you currently in the custody of Wayne County Jail?
No.
No, then you need to be here in person.
Okay. Let me call my mom real quick. Do I come to... I gotta look at my paper, because I don't even know where I'm going.
Sir, can you please lift up your phone so that I'm not looking at your hair and your face? Thank you. So, yeah, look at your paper, and the address is on the paper, right up here. Right up here. Here's the address, right here. Okay, sir?
All right.
So you can look at the paperwork, and if you don't have the paperwork, you can always Google it, and it'll tell you the address.
Okay. What time do I gotta be there?
Well, your court time was 9:15, which is in 2 minutes. So, as soon as you can get here, sir, and I certainly hope that you are not the one driving, since you don't seem to have a valid license.
No, I'm not driving. My mom's
Okay.
going to.
Okay,
Okay, I'll be up there.
we'll see you then, and make sure you're dressed appropriately, sir.
Okay.
All right, thank you. Okay.
Hello?
Hello.
Hi.
All right, we'll take up file 2013-52045, Sabrina Marino and Conrad Whitney, and both are here via Zoom. And this is the date and time set for hearing on Mr. Whitney's motion. Ms. Evans also here from friend of the court. Swear both parties in, both raise your right hands. You both swear or affirm any testimony you give in this cause to be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, did you say yes?
Yes.
Okay, thank you. And sir, what led you to file the motion?
So back when I was last, when my child support was last revised, I was making $18 an hour, and now I'm not making that. I'm making around 15 part-time. So I just wanted to get it revised because I was working full-time when I was getting 18.
Okay. And that was, and what, that was 2 years ago? About a year and a half?
Yes. Yeah.
Yeah, 2.5
No,
years.
2-3 years ago.
All right. And where were you working then?
I was working for Dish,
Where are you working now?
Best Buy.
What led to you changing jobs to a lower paying job?
It was work from home, Dish was, and it was during COVID. And after COVID, I just really didn't want to sit in the house all day.
So you took a job making less money?
Yeah, 10 hours a day at my computer was not fun.
No.
So the last calculation from 2020, I show the income used that was put in was actually the minimum wage at that time, $9.65 for 40 hours a week. At that time, you reported $11.50 an hour, working 16 hours a week. So you were imputed.
Wait, when was that? I'm sorry.
In 2020,
That was at Meyer. But after
last
Meyer,
uniform child support order.
all right. I talked to somebody at front of the court when I got the job at Dish.
Mhm.
And because that was the only time, like normally I would just implement my on the website. I would go to the where it says add income withholdings, and I would implement it on the website. That was the only time I called somebody and actually told them about like where I was working over the phone, and it was at Dish. I don't know if that was implemented. I wasn't making minimum wage then. And I know that for sure.
We don't adjust your support just because you change a job unless someone motions it in or it's time for a review.
Oh, okay.
Yep.
So what do you want to do?
I don't know. I was just hoping to get it looked at.
I can look at it. I can guarantee it's not going to go down.
Okay.
That's what I'm saying.
I mean, you're making $5 an hour more now than you were then. With the potential for having it run at a higher wage for a job that you voluntarily quit. It's your motion. You can withdraw it if you want, or we can crunch the numbers. It's up to you.
I can withdraw. It's okay.
All right. Now, I mean, the other party's on notice now that support would likely go up if it was reviewed, so she could file her own motion if she wishes, but you do have the right to withdraw the motion that you filed. So with that, I'll consider the motion withdrawn and the current order would remain in effect. All right.
Okay. Yep.
All right. We're all set for today.
He does have one more hearing at 2:30.
All right. I'll log back in at 2:30 and find you.
All right.
All right. Thank you. Ma'am, you understand what's going on?
Yeah, I do, but I actually didn't find out this hearing like through him. Like I know when you file a motion, you're supposed to send the paperwork.
Yeah.
And I didn't get anything. I just randomly called yesterday and then they told me about it. So she told me to make sure that you knew about that.
We sent all the information. We sent it to Virginia as well. Virginia got hers. It was all sent out.
It said it was mailed on May 10th. He's withdrawing his motion anyway, so I guess it doesn't really matter.
Yeah, I guess so. But is there anything I can do about, because she's 11 years old and he's never ever paid consistently her whole entire life. Like even when it was $100 a month.
Anything you can do to have the
Yeah, like
first?
yeah.
Yeah, sir, I see you are about 4,500 behind. Have you not been making your monthly payments?
I've been making as much as I could. I like with Best Buy, I actually enjoy this job. I've been picking up shifts regularly. I've been enjoying it. But I mean, been a busy few years.
Well, okay. It's $212 a month, and you paid $50 so far this month. Didn't pay anything in April. You paid about $50 in March. Or wait, you made a couple payments in March. You met the obligation in March.
August of 2021 was the last time he paid the full support. The 226 plus some on arrears.
So a year and a half since you paid the full amount. You know, what's going on? You quit a job making 18 an hour full time that enabled you to meet your obligations to take a lesser paying job. If you can still make ends meet, you know, I guess that's fine, even though I may not use that wage if I did run support in the future. However, if you can't meet your obligations, that was a poor decision.
Yeah. I mean, I just started this job. So, I mean, I get paid next week. You guys, I got notice that income withholdings are going to be happening. It didn't happen with my first paycheck. So I sent out what I could because it was a small check. It was only 1 week's worth of pay.
If you're making $18 an hour full time, why weren't you paying the $212 every month?
I set it up to where it would get withdrawals from my paycheck. I called the front of the court. I set that up. They asked me where the headquarters for Dish was so they could send the paperwork. And
so Ms. Evan, those payments weren't made?
No, there's no, what was Dish under? Because I don't see an income withholding order for Dish ever.
I can't remember where Dish, I don't remember. I just know it was Dish Network. I called.
Is that Axiom?
I don't think so.
When was this? What year?
2020. It was 2021.
Ecosphere?
Hold on. I'm trying to see if I can find out what Dish is under.
There's Ecosphere, Wild Wild West Tobacco, and unemployment in 2021. We had Walgreens and in 22, Murphy Oil.
It must have been the one before the Wild Wild West.
Ecosphere.
Yeah.
So, I mean, that went out in April of 21. And how long were you there?
A few months.
And that could be part of the problem because it takes time. If we don't get it to them quick, it can take 2 to 4 weeks before they even get it on their system. So you have a responsibility if it doesn't come out of your check to make sure it gets paid and to keep in touch and until it gets to that point where it's coming out like it should.
And that's what I did with this last check that I got from Best Buy. I sent as much as I could. Like I have bills to pay and stuff, and I know I have an obligation to make those payments. I sent what I could.
Sure.
How many other bills are you $4,500 behind on?
Not any.
How many of those other bills, if you don't pay them, could end up with you going to jail?
None.
Okay, so you need to make this one a priority.
Okay.
I mean, it's not that much. It's based on minimum wage. You were making twice that for some period of time.
Mm-hmm.
There's no excuse for not having made those payments.
Can I ask a question? You guys have is there any way you guys can look to make sure that the Best Buy is going to come out of the check?
We send it, it's up to your company to respond and take it out. So
I
it has
got,
been sent but not accepted they haven't sent us a response.
okay, I got an email. It says ADP garnishment wage notice. I don't know if I can hold this up to the screen and you guys can see it.
Sure.
But it's a wage garment and it says Best Buy on it.
Okay. Does it tell you how much is gonna come out? Are you paid weekly, bi-weekly?
I'm paid bi-weekly.
So it looks like maybe bi-weekly, you should have 143.22 coming out.
Okay.
Is that what it tells you?
It doesn't say anything.
Oh,
Oh, wait,
okay.
hold on. I can,
All right.
yeah, it doesn't. Yeah, it doesn't say anything. I just got two of them because of obviously the two cases.
Right.
Yeah.
Okay. Yeah, you'll just want to monitor that through your, I imagine you have an online where you can log into your ADP
Yeah.
and see. So if you don't see it coming out like it's supposed to, you need to make up the difference and probably
Okay.
contact your payroll and make sure
Yeah.
they don't need something. And if they do, you can call us.
Okay.
Okay?
So, all right. I guess we're all set for today. You need to make sure those payments are made. Do you have other
Okay.
income in the house that you rely on, in addition to your income?
Well, I have my wife's, but I'll pay like utilities. The utilities that are in my name, I'll pay. And then she pays the utilities that are in her name and she makes the mortgage payment of the house. And, yeah.
All right. Well, you got to understand, I don't care where the money comes from.
Yeah.
If it's not paid, you're the one that's facing jail time.
Okay.
I know it's not her obligation legally, but if she works enough or makes enough that allows you to work part-time for $15 an hour, and you don't have enough to pay it on your own, then it's got to come out of her money.
Right.
Unless she doesn't care if you go to jail or not, because
Mm-hmm.
I mean, that's the bottom line. You've been a poor payer, you're $4,500 behind on a $200 a month obligation. That's a lot of missed payments.
Mm-hmm.
And if that continues, Ms. Heaven's on notice now that the matter be set for enforcement proceedings.
Okay.
That can not only result in potential jail time, but a contempt fine of $100. It can result in your license being suspended, your passports being suspended, things like that. All right.
But that's the enforcement's not going to happen, right? Because I have like right now, because I have the employment and payments are going to be coming through.
I don't think it's been initiated. Doesn't sound like, but
No, I think you got a break because we've been short-staffed. So it's not been, and you've had an employer, so it's maybe been missed up until now.
yeah.
But like now that I've stated that like I got the income withholding notice, it's not going to be put into effect.
As long as we see your monthly support paid as it's supposed to.
Okay.
Okay?
Okay.
All right, and Ms. Moreno, for your benefit, and they have so many cases that in this type of case, the squeaky wheel gets the grease. If you call and say I'm not getting payments, that moves your case up for enforcement proceedings, the show cause and things like that. Okay.
Okay.
All right. And as I told you, just because I'm dismissing his motion today doesn't mean you can't address support in your own motion.
Okay.
All right, we're all set for today. Sir, don't hang up. The other party in your other case is logged in, so we'll just start that one now.
Okay. Sounds good.
All right.
Thank you.
Ms. Moreno, you're all set. Yeah.
Oh, no.
All right, we'll take up file 2020-57342, Virginia Ball and Conrad Whitney. Both are here. Matter was set for hearing on Mr. Whitney's motion regarding support. Sir, I know, because we just had a hearing, but Ms. Ball wasn't here for that hearing. What led you to file the motion?
Just, change in wage, but we've from the other hearing, we established that it doesn't really add up to what I'm wanting. But unlike my previous case, I have a consistent relationship with my daughter, and we're getting her on the regular. Me and Miss Ball have an out of the court arrangement where I get her for my time and stuff.
All right, well, let's not skip ahead here. Ms. Heaven, what was support based on last time? It was run at a different time, so maybe it was based on different income. I don't know.
It was. There was a December 16th, 2020 hearing. $13.25 an hour times 40 hours was used for Mr. Whitney.
All right, and the support is currently three something a month?
Support is $371.
All right. So, sir, a different income was used at that time. The motion, or it came up for hearing at a different time anyway, so you had income when this case came up for a review or a motion that you didn't have, I guess, when the last one did, even though it was just a few months apart. Are you still interested in pursuing your motion then at this time?
I would like it.
Now.
I'm sorry, what was that?
I mean, you're making more now per hour, I guess.
Yeah. I mean, we can just withdraw it.
All right, so support would remain as is. Ms. Ball, you're here for this matter. Do you have anything you wanted to address? Mr. Whitney, I think, thought that higher income was used when his obligations were run back in 2021. Requested to withdraw the motion, which means support would remain as is, okay?
Yeah, that sounds good.
Okay, sounds good then. Support would remain as is, motion to be dismissed.
Thank you.
Welcome. Great to see you. Thank you for your patience. Have a great day. Stay safe.
Ms. Richardson, call me if you have any questions.
And then Miss Rudder, make sure drug court knows that she's in person and not on Zoom, so that they can come in person and not Zoom in.
Okay, I believe Mr. Yancey should be coming down, but I'll call back and make sure they know. Thank you.
Okay, thank you. All right, I'm ready on Watts. I'm gonna try to put my other device back in the waiting room and see if I can manage on my main door. I'm not going to keep bringing Mr. Watts in off video. I'm not going to keep waiting for Mr. Watts. I'm not going to keep waiting for Mr. Watts.
Your Honor, I've been in here.
Yeah, you're supposed to. You're supposed to wait for me. But when I bring you back in, your camera should be on and you should be stationary, seated in an upright position, ready to go. I shouldn't have to sit here and say, we're ready on Watts. We're ready on Watts. I shouldn't have to do that. I am ready on Watts. This is case number 146472101. The people of the state of Michigan versus Disanto. Trayshawn Watts, defendant, is charged with 1 count of controlled substance possession of marijuana. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Deontay Watts. Mr. Watts, sir, please say your full name.
Deontay Trayshawn Watts.
Thank you, Mr. Watts. Today, I thought Mr. Watts was in front of me before. He wasn't. This isn't.
I think I zoomed in on the mistake on your curve.
Oh, on the wrong day. Okay.
Yeah.
All right. Okay, so today is the day set for a pretrial conference from a 2014 case where the charge is possession of marijuana that is currently legal. How are we proceeding?
Your Honor, at this time, to the age of the case and the nature of the charges, Your Honor, the people motion to dismiss in the best interest of justice.
Okay. Now, I don't like the fact that it's legal. Mr. Watts, what you doing, sir? Why I can see your eyes and nothing else? Okay, there we go.
I'm making sure my face in the camera. And last time I came out, I wasn't sure if you meant to zoom me in last time because you was calling for Brooke, so I wasn't sure if you wanted my camera. I'm sorry for the inconvenience, though, Your Honor.
Thank you, Mr. Watts. I appreciate it. You seem like such a nice young man. I want you to stop smoking weed, though. But I know it's legal. You don't have to say nothing. I don't want it to be legal because it smells so bad. But to me, anyway. All right. The people have moved to dismiss the matter in what they said is the best interest of justice. And I guess it might be, since now, the marijuana is kind of legal. So I am gonna dismiss the matter in that the people no longer wish to prosecute you, Mr. Watts, based on the age of the case and the current state of the law. We are going to mail you a copy of that order of dismissal for your records, okay?
Thank you, Your Honor.
You're welcome. Have a great day, Mr. Watts. Stay safe, and I ain't gonna say nothing else.
You too, Your Honor. You have a good day, Your Honor.
Right.
Thank you.
Thank you. All right.
Something I didn't understand. Understand what happened here. I'm reading the pre-sentence report and it doesn't make any sense at all.
Yes, Your Honor. The victim in this case advised that she was, her neighbors were going out of town. She was going over to feed the animals. That her ex boyfriend, who she has a child with, showed up while she had left the baby in the car with the car running at the neighbor's house.
Yeah. So far, that's what I'm reading. Yeah, but
he shows up, tries to get her in the vehicle and take the baby. He pulls out a taser and she grabs the baby. They kind of fight over it, and he tases her. She said it did hurt a little bit, but then he takes her vehicle and flees, and he was not apprehended till sometime later, where he went, I believe, somewhere in northern Texas. He had also to mention that I don't believe she had saw the defendant over a year at this point, so it's kind of out of nowhere where he showed up.
that's okay. All of that I understand, but that's not what the indictment says. You didn't say anything about what the indictment says. It says cause bodily injury by striking the victim with the automobile.
This was, Your Honor, it was re-indicted.
It was.
Yes, Your Honor, to a robbery. It was initially filed as an aggravated assault and cause number 22-41243. It was re-indicted to cause number 23-41313, which is a robbery. I apologize, Your Honor.
Okay. I'm following you now. So
Yes,
we've
sir.
got 41313. Okay, I understand now. You pleaded guilty here earlier.
Yes, I do.
Pre-sentence report was prepared by the probation office. Everybody's had a chance to review that.
Yes, Your Honor.
And there are no changes or objections to it?
No, none from the state.
All right. Then it's made a part of the record for all purposes. Anything you want to say?
Yes, Judge. And we wanted to point out, Judge, on the PSI on page 4.
Yeah.
I think one of the biggest things in his advantage is the screener.
No, let's walk back. Page 1.
Right. He's talking about
let's see.
I see. I know.
I told her to get in the car, and even though I did have a taser, I did not use it.
Never used.
Well, isn't that interesting? Because you pleaded guilty under oath to intentionally and knowingly causing bodily injury to the complainant by tasing Ashley Jurek. So who did you lie to? My officers or me? You can't have it both ways. You're not going to play games with the court. All right. Can you explain that?
I just
Lied. You lied somewhere. Here, you lied under oath. Then when we put you under oath, when you said I plead guilty, are you pleading guilty voluntarily to all the elements of the crime? When you said yeah, and then you turn right around and tell my officers, although I had a taser, I did not use it. Why would you screw up like that? Why would you lie?
I just copped out to it because I thought maybe it would be a great deal.
Say that again.
I don't really understand. Like I just
wait. Do you understand the truth versus a lie? Are you telling me you committed perjury when you pleaded guilty then? Which is another criminal action.
No, sir.
You committed perjury when you pleaded guilty to this crime, which says you tasered her. That's what you swore under oath.
I did those crimes, sir.
Is that right?
Yes, sir, I did those crimes.
So you didn't tell the probation office the truth?
I apologize. I'm sorry.
All right. Anything else?
Just the reason why I was going to ask you to consider giving them probation, as I was saying earlier, I think the good thing is that the score was a low risk level. So I thought that's something positive, that he's not going to be a big risk if he's on probation.
I know it begs the question. So why is he here? He's such a low risk.
Because I guess with the TRAS screener.
How many times have you been to prison?
Look,
I'm not talking to you. I hope I know how many times you've been to prison. Well, I'm talking to you. Why would you even answer that question?
I'm trying to help him out. I'm trying to help.
Right.
And I was just looking. I see.
Oh, look, the last time you went 4 years.
Yes.
Right. Time before that, let's see. You were on probation, that was revoked, and then you did 1.5 years in state jail. So you've been to a prison facility 2 separate times, not counting your misdemeanor 30 days jail in Bowie County. Is that right? Or am I missing something?
He's talking about this. Yes.
You got forgery, which is, of course, deceit. Then evading arrest and detention with a motor vehicle. Later in 2017, you pick up 4 years in prison, right? Yes. All right. Okay. Go ahead.
So Judge, he was asking, will you really consider him for probation? And I understand that with this particular offense, he apologized for not being totally truthful about the taser incident. But Judge, I was asking you to consider this is more of a crime of a passion type thing, at least from my understanding. He really loves his son. He spent a lot of time with his son. His son has been a big part of his life. And when I met with him, when I talked to him,
how old is your son?
He just turned 3.
He turned 3 years old.
5/11/20.
And what happened was the young lady in this case, the complainant, and I'm not trying to justify conduct at all, but I think that when she was not letting him actually see his child, and he had that relationship with his child, he blew up and he did something that he absolutely regrets. Now, was that right? No. But at the same time, Judge, with the passions involved, when you got a man that really loves his kid, and he's going to speak for himself, I don't want to speak for him. Can you tell the judge just exactly what was the background with the kid, the ladies, and what was going on that kind of caused you and pushed you to the way what you did? And I know you sorry for what you did, but what was the circumstances? Because if you tell us the circumstances, the judge might have some leniency on you. What was the circumstances?
The circumstances were, Your Honor, for 2 years, I decided that when I went back home to Texarkana, when we split up, I had hopes with getting back together, but my drug addiction with the methamphetamine and stuff, you don't even have to do it. It can mess your brain up real quick.
No, don't blame it on the drugs. That's your choice.
No, yes,
your choice. Your choice. You know.
Yes, sir.
You know what it can do to you. You made a choice rather to get high as opposed to being responsible for a family.
And
you chose a selfish act. Okay.
So what happened with you?
That's why you're here.
Yes, sir.
In an orange jumpsuit.
Yes, sir.
Because it's all about you, which is not the way a family works.
It's not.
So tell him about what happened when leading up to the kid. You was telling me that you weren't able to see your kid. What happened?
I moved back down here, was in the Salvation Army trying to get myself right. And for that whole past 2 years, it was like I was paying for pictures through text. And I would drive down there 350, 400 miles, and I would just want a hug. But see, that's where I went wrong, was going down there without letting her know I was coming. And I learned she can't do it like that. And she didn't want her son around any kind of meth use. And
Yeah. Good for her.
That's true. I mean, I did that.
Good for her. You put the family in harm's way. That's your choice. That was your choice. Where are you getting the meth from again?
I would get it. I got it down here, and I got it.
Who? Where'd you get it from?
Where
are you getting it from?
Glass House, the road Glass House.
Who is it selling?
I guess his name's Sammy. They called him Sammy. I think his first name's like Isaac. I'm not mistaken, but they called him Sammy.
What about the cocaine? That was you were using that regularly in 2013, right?
The cocaine.
Where were you getting the cocaine from?
Cocaine. That was mostly in Texarkana. I would just get it from people out in the neighborhoods.
And then let's don't forget 18 years of cannabis use.
Yes, sir.
Yeah. Where were you getting that from?
That would be in Texarkana also. I never really smoked anything other than just meth down here. I've never used intravenously.
So but you were never addicted to it? To any of this?
Yes, I was addicted to it.
Okay.
But I just decided that I don't want I just do one drug now, that I just would do one drug. I don't even smoke any weed or anything.
Wow. And just what he was asking is that when she wouldn't let him see the kid, and she had every right to it being using the drugs, I think that kind of made him make an irrational decision with her, because you did have a relationship with your kid.
I sure did.
Right. And I think when she told him that you could not see your kid because of the drugs, his mind made some real bad decisions at that point. And we're not justifying it. He's just asking for some leniency, because that was more of a passion type situation. And not being to see his kid really hurt his heart. That hurt his heart a lot.
Well, he assaults the mother in front of the child.
And I'm not
the way this goes.
I'm not defending it. I'm just saying
that was not an excuse.
But with the drug problem, if you put him on probation with him being low risk, he can take whatever drug classes or programs that probation, and I know probation's here if they will work with him. And I guess he could do the anger management, the moral recognition classes. He could also
anything. You've been in drug rehab 3 times. One of them is an absolute failure. But you're assuring me that you can take care of it by going back. You've been to SAP 3 times. That's the most and failed. What state say?
Your Honor, the defendant in this case, he wasn't able to see his child again because of his drug addiction. That was due to his own fault. Detective soon after this called Pennis' mother trying to locate him. She advised she didn't know where he was. She calls Detective Powell back and says, I've spoken with him. He took the vehicle and did this because he wanted to see his child. Then he tried to negotiate by saying that he would give the vehicle back if he could see the child at that point.
Well, that's not the right way. Of course, this is what courts are for, to handle family domestic issues.
And Your Honor, I believe Detective Powell
put it in your own hands. Someone who's as irresponsible as you, it's going to be a failure.
Very, very irresponsible.
In this report, it says that Detective Powell states that he needs to go to prison for what he did, and that he'll do it again. He doesn't deserve probation. He'll do it again. He has received probation, as the court knows. He's also received the 4 years TDC, and in keeping consistent with this court's rulings and how he normally operates, state believes 8 years is more than a fair offer on this case, and that's what we're asking for.
What else? Judge, without me belaboring the same point, I know he made a real bad decision with that, his kid, but I do want you to bring what has statement of interested parties, All attempts to contact the victim, Ashley Jurek, were unsuccessful at this time. So to me, when I read that, the victim in this case is not reaching out to the probation department saying, hey, put him in prison, put him in prison. Apparently, she did not respond to their attempts. I mean, that's what it looked like.
Well, I have, well, with that, Your Honor, I have spoken with the victim and she did wish for him to receive pen time. She did not say how much, but that was her request with me when I did speak with her.
Well,
He's got this prior felony conviction in 2017 out of Bowie County, correct?
Yes, sir.
Or 4 years prison. So for whatever reason, the state did not elect to use that as a prior enhancement, correct?
Yes, sir.
That's correct. Okay. Anything else?
It's all.
If nothing further, I'm going to find that you have pleaded guilty, sir, voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt and support your guilty plea. To make that finding, I hereby find you guilty beyond a reasonable doubt of this second-degree felony of robbery. I am following this agreement, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You're looking really at 5 to 99 life in this. And so you're punished really at the low end. But it just, you know better. You've made poor choices. You're going to continue to make poor choices unless you somehow decide, with all the opportunities that you've had in drug rehabilitation, 3 times in drug rehabilitations, it's just a matter of you deciding that your family is worth more than you live and hide. Until you decide that and make a conscious decision that you're going to quit being selfish and start being selfless, you're going to be back up here in front of cases, because that's what life is in making a good choice versus a bad choice. Is it all about me, or is it all about family and others? Who do you put first? You've been putting yourself first until you decide that you're really number 3rd between family, the creator, and until you start respecting and honoring others, most importantly, your family and this young child who you've done nothing but exhibit poor role modeling, which is easy enough to change if you want to. This other case that's pending is going to be dismissed?
Yes, Your Honor.
It wasn't superseded. It wasn't a superseding indictment, was it?
No,
replaced another?
Well, yeah, actually, it, yeah,
you need to send a dismissal with a separate cause number.
Yes, sir.
All right. Anything else on this man? Okay, that is all. You have Rick's Watson?
Yes, he's ready, Judge. And that NICOR is the dismissal.
Okay.
Could be good. Rick's
Watson.
Yes, Your Honor. We're here for a bond modification as part of her bond order in December of 2022. She was ordered to stay away from the family home and to have no contact with the alleged victim. We're asking for both of those conditions to be modified. Recently, Miss Ollie has been diagnosed with cervical cancer and has started treatment for that, and part of that treatment has included major surgery. It's being unable to live in her own home has caused her major issues with recovering from this major surgery and taking care of her health. She's had to live out of her car due to this bond condition, and obviously her health is very important, and So we are asking for one, the stay away order to be amended and also for the no contact order to be taken away. It is my understanding after talking to Miss Ollie, and I believe some other folks are on the Zoom that can speak to this, that there was a defects case that was opened up in addition or, related to this incident. And it's my understanding that that defects case has been closed. And that it has been closed because the allegations from the child, she admitted she made them up. I was told DFAX was going to be on here to speak to that, and that the child herself is also on the Zoom call. So I can turn it over to the DFAX representative, whoever they are. I'm not sure which screen it is, to speak to that.
Is anyone from DFAX here? No one from DFAX. What do you know, Bostic? Anything I need to know?
Okay.
No new information, no new arrests. I think this is her only, actually.
All right, Miss Patton, let me pull it up and look at it. Anything you want to say yet, Miss Patton? Are you
Your Honor, honestly, I haven't heard anything from DFAX. If Your Honor is inclined, I would like to hear from the minor child. My position right now is objecting it based upon what's alleged. These are serious allegations. I am sympathetic to Miss Ollie's diagnosis, but these are very serious allegations, and my position is to object. If Your Honor is inclined, I think she is on here, Sanaya.
All right, Sanaya. How old are you, Sanaya?
16.
All right, can you turn your camera on for me? All right, if you could raise your right hand, Sanaya, do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Yeah. All right, you got to speak louder and be still. Sit down somewhere and be still, okay? Got to see your face. Okay. Go ahead, Miss Rondon.
Hi, Miss Ollie. I'm just going to ask you a couple questions. Regarding the incident that happened in December of 2022, will you tell the court whether or not you have stated to DFAX that this incident did not actually occur?
It's you, Sanaya. She's asking you a question.
Yeah, Miss Sanaya Ollie, did you hear my question?
No, can you repeat it?
Of course.
Okay, Miss Sanaya, if you're close to somebody, you need to get away because there's feedback.
Mm-hmm.
Is the defendant currently in the same?
Whoa. Are y'all at the same house?
That's what it looks like.
Sure does.
Yeah.
So right now, what you're telling me is you're violating your own bond conditions before I say you can amend them.
I had no choice. I've been reading.
Stop talking. Stop talking.
Miss
Ollie.
Stop
talking. Miss Ollie, stop talking. Absolutely nothing you say is going to help you right now. Miss Patton.
Your Honor, based upon that, my original, I would object. I think it still stands. She hadn't even stayed with the conditions as are right now. She's in the home with her. And how can the child and the victim in question be safe enough to tell me what's really going on if she's in the house with her?
And Miss Rhonda, this is not me doubting you. I can feel my blood pressure going up. Wait a minute.
I agree, Your Honor.
Miss Ollie, I am sorry for your condition. However, I am not sorry that you couldn't follow instructions. I mean, and the nerve to show, it's like, what in the world? You didn't even try to hide it.
You and lied to you.
Miss Ollie.
Absolutely nothing you can say. Miss
Try to
Rhonda does not want you to say a word. It is not going to help you. So Miss Rhonda, I tell you what, you can place this back on another time. I'll give you a chance to have a conversation with Miss Ollie. And then put it back on for another motions hearing. But
Thank you, Your Honor, I do appreciate that chance. In addition, I know it's not changing anything today, but I was told there are documents supporting the dismissal of the defects case and other things that were also allegedly turned over to the DA's office.
Sure.
Since this case was not originally mine, I did not have a chance to get my hands on those documents before tonight's hearing. I will get those documents before we come back, and I will share them with the state in advance.
Ms. Travoria, what do you think the reset date will be for her?
It'll be sometime the end of July.
Is that okay, Ms. Rondon? Or of course, if you send stuff to Ms. Patton and y'all come up with a consent, that's fine too. I mean, just let me know.
Ms. Rondon, and excuse me, Your Honor, for interrupting you. I know you said a defects case was closed, but I'm concerned that a defects case was closed with the thought that she wasn't living there, and clearly she is. So I'm concerned that a defects case was even closed out based upon the information that we've learned here today, because it doesn't seem like it was closed out based upon all the information being given, being truthful.
I have.
I'm sure Ms. Rondon will get to the bottom of it.
I will get to the bottom of it. I do have a name and number of the defects caseworker. So they will be my first call. And I will.
Thank you, Ms. Rondon.
Yes.
Yeah, and if you want to send that to us, you can.
Absolutely.
All right. Best of luck to you, Miss Ollie. Have a good evening. But you need to leave where you're at. All right. Let's see. Roderick Wimby.
All right, so we can have someone from the state.
Hank Wilkins for the state judge.
All right, court is calling 2023 CR 3770, State of Texas versus Donna Lynn Ellis. Can our parties announce for the record for the state?
Hank Wilkins for the state. And we're ready.
Defense.
Bill Caldwell here for Donna Ellis. We're not ready.
All right, this hearing was scheduled at 9 a.m. Today. It's now 11:07 a.m. Your client did not answer docket call. Defense, do you have any idea where your client is?
I do not, Your Honor. I've had no contact.
All right. State?
Judge, we asked for bond forfeiture this time.
All right. Because this is a PR bond, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right. You're welcome.
Are we excused?
Yes.
Okay.
Thank you.
I'm Gail.
All right. Caroline, on this one, that's a judge's warrant and they're remanded. All right. The parties on Migdalia Salazar. All right, counsel, it's the court's, we're going to go on the record. The court is calling 2021 CR 9849, State of Texas versus Migdalia Salazar. Can I have parties announced for the record for the state?
Travis, thanks for the state of Texas.
Defense?
Charles Peters.
All right, Mr. Peters, where's your client? My understanding she was in court and she left.
I'm not sure, Judge. My office is attempting to contact her.
All right, my understanding is she was in court and she left the building.
I have no idea, Judge. I have just messaged for my client for the office to try to contact her.
All right, for the record, the court is going to note that your client was present and your client left. So the court is going to hear this order for judgment on nunc pro tunc. Have you had a chance to review the state's motion for the judgment? Sorry?
I have.
All right, are parties ready to proceed? All right, court is going to grant the state's motion. All right, let your client know that their case is going to be reopened. Is there anything else from either side?
Nothing from the state. Cool.
All right, and if your client needs to appear, counsel.
So when you say the case is going to be reopened, on what grounds?
The state filed a motion to dismiss. According to their motion, they filed the motion in error. What they did was they filed a motion to dismiss based on the fact that the defendant was convicted or granted deferred adjudication in another case. My understanding is your client was not convicted or granted deferred adjudication in another case. And so that it was incorrect. And I have notated on the motion for dismiss after the court signed it, it says state and defense state reason for dismissal incorrect. Both requests dismissal withdrawn. So on that date, both you and the state asked that dismissal be withdrawn and another dismissal be filed. And the court is not in receipt of another dismissal, and the court is not signing another dismissal until your client makes an appearance. Now, with regards to the non-proton, the court has signed it because the dismissal was entered in error. So the court assumes or presumes that the state is going to reopen the case. And for the record, the court is again noting that your client was here and your client left the court.
And on that matter, I do need to address an issue on the record.
Yes.
It's my understanding that the state has applied for a subpoena in the companion case against Fidel Ayala. It's my understanding that there was an intention to serve Ms. Salazar today at court with that.
Well, if everybody would read the case law and realize that when someone is supposed to appear in court, I don't know if your client knew it or not, but once they appear in court, if they're here for a court hearing, technically they cannot be served a subpoena in court. But obviously, either your client was given bad information or your client decided to leave because somebody informed them that the state was attempting to serve them with a subpoena. When a person is ordered to appear in court, according to case law and the rules, they cannot be served at court when they have an order to appear in court.
I understand that. I also needed to address
who informed her to leave the courtroom when the court ordered her to be here.
I didn't tell her to leave, Judge. So I don't know why she left. So, and we're attempting to contact her. One of the questions that I wanted to address is that the original dismissal was actually signed and entered. I received the rejection notice of the case so that it is dismissed, which I believe ends the court's ability to order her to appear.
Here's the thing, what I need you to understand. What I want you to understand, if both the state and the defense on that date knew that that order was incorrect, that the state had filed the motion for dismissal incorrectly and said that she pled in another case, both the state and the defense told me, Judge, that's incorrect. She did not plea in another case. And then what ends up happening is another motion to dismiss is submitted to the court. And what I wanted to know from the both parties, because my mind is a steel trap, I wanted to know why the case was being dismissed. The state said it's because we cannot get in touch with the complainant. And I asked the state, who is the complainant? They informed me it was a child. I said, how can you not get in contact with a child? And I said that I wanted the caseworker here because both the state and the defense informed the court that the CPS caseworker had closed the case. And I said, well, I would like to hear that from the CPS caseworker. And both parties like, no, that's what the CPS caseworker said. And I said to both parties, do you want your bar card on the line for that? And then both of you all backed off and said, we will get the CPS worker here either by Zoom or in person.
I would actually like to correct that, Judge. I believe at the time that I stated that I was willing to proceed without CPS caseworker.
No, you both said that you would not put your bar card on the line just by saying that, and that the CPS caseworker would be here.
I do also would like to address that I believe that there there was a second dismissal that was submitted with with that different.
Which I did not sign.
Is it still part of the court's file?
No, because I did not sign it.
So it was discarded?
I did not sign a dismissal. And what everybody needs to understand is that the court can sign a dismissal or not sign one. I chose not to sign it. And if that dismissal were placed in the court's file, it would not be valid because the invalid dismissal that I just did a knock on would be the law of the land. So thank you. Court is
I
calling.
have one final issue to
Yes.
address on the record. It's my understanding that there was an ex parte communication between Whitney Mitchell on behalf of the state of Texas
To who?
and the court.
No.
Your Honor, he's just referring to discussing the scheduling of this hearing yesterday when y'all discussed that we have this hearing.
No, I told the court coordinator to put this on the docket for today. And this case was supposed to be on the docket before then, because when you both were here, I gave you a date for you all to appear. So the court does not do ex parte communications. Thank you. Court is calling 2023 CR 3276, State of Texas versus Robert Valdez. Can I have parties?